Good morning, Madam. Steve, sir.
Thank you, sir.
Would you like 5 minutes?
Yes, sir.
Okay.
Good morning. May it please the court and my learned counsel, opposing counsel. I want to preface by saying I've done this a couple of years, and it's been an honor being opposed to defense counsel in this case. They have acted incredibly professionally and fairly. We have not agreed on anything in this case, but it's been a real pleasure to oppose them.
I was glad to hear that.
You know, that's nice to hear.
Yes, sir,
Especially
especially,
the seminars we have, it's really nice to hear live.
thank you.
Go ahead, sir.
With that being said, they're all wrong. In this case, a little preface background. It's like a submarine closure, and there's 10 little toggles and switches and screws and bolts.
The picture in the expert report was.
Yes, I have the picture in case anybody wants to see it.
Big wing nuts.
Yeah.
We took those off and we put regular parts.
Right. And think about if this were a submarine, because in a sense, it's a submarine type case. They put these two men in a virtual certainty of this door blowing. Why? When you look at the facts of this case, they knew that all these switches, toggles, bolts, and nuts were bad. They replaced them in 2 of the other doors and didn't bother in 3A and 3B. Then they go in there, there's a leak. They tell their own employees, hey, you got to go in there. They put a tag out sign. And the other key is they lower the pressure. They take it off, they turn off.
Did they turn it off? I thought
They turned it off. Yeah, they turned the system off. Why did they turn the system off? Because they knew it would blow, or they knew there was a substantial certainty that it would blow. Now it gets worse.
Or there's an OSHA standard that says you're supposed to de-energize.
Yes, and yeah, correct. And OSHA violated them, clearly. I mean, they had to pay fines. I don't think the amount of the fine is relevant, but they were found guilty, they had to pay fines.
Ultimately, the part that you have to confront, right? This is everything that you described. Let's just assume for the sake of this discussion that it all meets the standard for negligence. But then we get into the statutory exception. And I'm trying to think of a good analog for submarine, but basically you've got to fly a fighter plane through the statutory text to establish the exception. And that's where your case fell apart in the trial court, right?
Yes, sir, absolutely.
So the part that I'm hung up on here is deliberately intended and I don't think anybody here is contending deliberately intended. I think that you're focused on the second part of the exception. Engaging conduct the employer knew based on prior similar incidents or on explicit language specifically identifying known danger was virtually certain, and the employee wasn't aware, or the employer wasn't aware because it wasn't apparent, and the employer deliberately concealed it. I think the trial court found that those elements were lacking here, and you're hamstrung, I would say, by case law on virtual certainty, and ultimately your expert's report, which the trial court found was conclusory. He did, this isn't a fact opinion where the rule allows a matter of ultimate fact. This is an ultimate legal conclusion, and your expert just parroted the language of the statute on the tail of all the OSHA violations and all the things we can agree would probably be negligence. To say, well, this means a virtual certainty, but that's illegal. The way it's framed is a legal conclusion, and the trial judge bought that. So help us understand why we're to make a different conclusion here.
Well, I think there's a multi-argument in what the court's saying that I have to overcome. There's no question that the burden is clearly well beyond simple negligence. If this were simple negligence, frankly, I don't think we'd be here. This is a strict standard, virtual certainty. The court said, if I had considered your expert on page 37 of the transcript, if I had considered your expert I'd rule no summary judgment, but I'm going to ignore the expert's opinion. Now, I'm going to ignore the expert's opinion. He doesn't give a reason why. He just says, I'm not going to. Experts give final opinions on all sorts of things. It does it in a medical malpractice. Does it read your standard of care? In a personal injury case, is there a permanent injury?
I'm going to stop you for a minute.
Sure.
Raise this issue with Bruce as well. Here the facts are not in dispute. And so the ultimate question for summary judgment is whether as a matter of law, the standard is met. The trial court isn't going to need, and that's not what experts are for, to assist the resolution of the legal issue. The facts are already crystallized. So, I think you suggested that the trial court was somehow required to undergo Darwin analysis, but that's not what the rule says. The rule says an objection, which you're limited, to the affidavit is sufficient, and the trial court said, this is a legal question, and I don't need the expert's affidavit, which is essentially a legal conclusion, so I'm disregarding it. In what way was that improper?
Well, the legal conclusion is, I disagree with the trial court that I think that the expert give a factual conclusion, just like doctors do every day and everything else. The opinions that they gave, but even when you look at just the facts, do the facts support a question that a reasonable jury could support our side of the case? I would submit to the court that a reasonable jury almost will agree with our side of the case. That's the standard in summary judgment.
Well, by clear and convincing evidence, don't forget that.
Yes, Your Honor.
Reasonable jury by a preponderance of the evidence, it's clear and convincing evidence.
Yes, Your
It's a
Honor.
big high hurdle. I still think that the court considered your expert's affidavit, but your expert lists many things that I have here. They should have further diagnosed it. There were OSHA violations. They knew after turning on the circulator back on and the resulting pressure could be higher than normal, failed to exercise reasonable care and transferring work to Zachary. Those all appear to be opinions concerning negligence, because here the hurdles you have are the employer engaged in the conduct that the employee did based on prior similar incidents. So would we all agree there's no prior similar incident, correct? With this.
In this particular fact pattern, I agree.
Different screws or not?
Yeah.
Okay, so that's that. Or explicit warnings specifically identifying a known danger. Are you arguing that TICO should have warned your client?
Absolutely.
Okay.
Even though Mr. Ganser had been there earlier working on the same patch on the same day before the blowout.
But that's in fact a dispute. Mr.
Well, your
Ganser.
expert, Mr. Zachary, I want to.
Yes, and forgive the
Your
court.
expert, those call your expert.
Yeah, how about expert Z?
Here's his conclusion. Deposition testimony indicates he seems to feel that there was an earlier inspection by Mr. Ganser. Indicates the assignment on October 24th to seal the QB door was given to Zachary on the belief that Zachary's staff had worked on the same door very recently, and that it should fix what started. Mr. Ganser had been involved in that earlier work. However, in my opinion, this is what had me kind of scratch my head. However, in my opinion, the nature of work and hazards presented on October 24th were different from the nature of work and hazards that existed during the earlier work. The risk was not apparent. Why was the trial judge just free to, that is, of all of the conclusions, that one is arguably best stated as a non-legal conclusion, but I have a hard time just scratching my head and accepting it. It's the same door, the same leak, the same day, the same employee addressing the same problem, but it's somehow a different risk.
Your Honor, that's not the same employee. In fact, the two employees he's referring to were TICO employees who went in earlier that day.
Okay, I'm getting confused.
The TICO employees actually broke two of the prongs, making it an even more dangerous situation. It's not just that they were bad. The TICO employees went in and broke two of them. They had a leak.
Mr. had not been involved in that earlier work?
That's correct. He never went in there until almost the moment.
Your expert seems to believe he was.
and that, I live partially with his report, but I also live partially with, I also substantiate that with the facts of the case, that my clients, Mr. Ganser and Mr. Carter, neither one of them ever went in there that day. If that needs to be fleshed out at the trial court, I'll be happy to do that.
If you had evidence of a prior leak with this door and prior problems and higher than normal pressure, or higher than standard pressure, that might help, wouldn't it? I mean, this is the first time this door leaked. And when the TICO employees went there, it's my understanding that some screws or bolts were on the floor, 3 of them or something, they put them, tighten back. And then I think that when your client went, he may have told somebody, to his credit, go turn down the pressure or turn it off, right? And it's then when he's hurt while his coworker or someone that he told to reduce the pressure, turn it off. That's when that
It's
happens.
John Lucas, right?
I don't believe that's factually accurate, Your Honor.
Oh, that's fine. You can correct me.
Yeah, no, what happened is the 2 TICO employees went in on a known leak. They broke it worse. Remember, when the TICO employees went in, TICO turned down the pressure so it wouldn't blow, knowing that there would be almost, imagine if you're working on these toggles at the court seen the picture, you start loosening up with the pressure on, it's almost, as our expert said, and as our folks will say at trial, it's a virtual certainty that door was going to blow. So what do? They turn the pressure down. They let their employees go in. Their employees then break 2 more of them. Then and by the way, they tag it out, and that's a very important issue too. Then they call, and there's still a leak after they do this. Then they send Carter and Gansner in without tagging out, without turning the pressure down, and without Gansner and Carter. They know there's a leak, but they don't know anything about it. They assume that the pressure's down, but
Okay, so it looks like your expert, you all maybe aren't on the same page about factually what's happening there, but regardless, irrespective, on the employee knowledge side, in this case, Mr. Gansner's knowledge side, is there any dispute that he's not aware that this is a pressurized hatch and that if it's leaking, there's some kind of risk there? Is there any dispute on that fact?
no, I don't think that's a dispute, but the fact that there are broken toggles that's the problem. That's the real problem. That's where they knowingly send in the new employees, Carter and Gansner, into a situation where there's broken toggles and a leak. And we didn't know about it.
Are they readily identifiable to anybody that approached this lid? Would your employees, your client or anybody that walked up to this lid would say, those fasteners are broken or missing?
The answer to that is they literally, yes, they walk in there, they go, oh, and boom. In other words, it's not like they were in there working and they were doing something where they could have said, oh my gosh, it's leaking, there are broken toggles, let's get out of here. They never had a chance for that.
So help me with this then. If the trial court erred in not accepting what was arguably the legal conclusion that this is a virtual certainty, even though there's not really, the expert never really gives us any other actuals or any other examples of how this happens or where this happens anywhere. But if we accept for the moment that it's just enough that he parrots the statute and says it's a virtual certainty, how do you're the appellate judge for a moment, you have to write the opinion such that not every single, because here's the thing, once an accident happens, the happening becomes a virtual certainty, right?
Correct.
So the statute contemplates a temporal point in time in which it's prior to the happening. So it seems like what your expert's done is basically done Monday morning quarterback and says, look at all these things that were done wrong. The hatch blew. It was a certainty that was going to happen. But he has the benefit of using all of the information. He's only using all of the information that has already been gleaned that led up to what we already know happened. So how do you write that opinion such that we're not doing Monday morning quarterbacking and having an expert saying, look at all the things they did wrong, and oh, it blew up and an employee got hurt. It was a virtual certainty that was going to happen. How do we separate those cases from the ones where it really is a situation where at the time of the events occurring, any employer would have looked at that and said, that guy just would have loved to listen.
I
Don't
know.
do that.
That's a wonderful question, and
I get one every now.
remember, I'll put my lawyer shoes back on, or my advocate shoes back on. But if I were an appellate judge, I would look at the following situation. When they sent their own two employees in, they knew there was a leak. So number one safety thing to do is turn these pumps off. Then they get reported, oh my gosh, the leak didn't go away, and oh, by the way, we used the wrong tools and we broke two toggles. Now, that's the virtual certainty right there that they knew that if they send somebody in with broken toggles now, and they don't turn the pressure off, it's a virtual certainty that this door is going to blow.
Okay, so that's the first time that's ever happened, correct?
That's the first time there's ever been broken toggles and the pressure not turned off.
So we must have a warning. You're saying at that moment in time, there has to be a warning.
I would say once they knew they were
The door
broken,
had never blown open, they're supposed to turn around and say to your client, this is gonna blow. This is an OS moment. Let's get out of here.
they always, because when they send people in, they always turn the pressure off, and they don't have broken toggles. That's the problem. I believe that's the problem on Pico's side, is they send them in without turning the pressure off, knowing that there were broken toggles. And of course, the other parts are kind of, supplement, I believe. But that's the key part of it. And without tagging it out and telling, remember, if they tagged it out, they wouldn't have gone in there.
You can keep going for more.
No, sir. If I may, thank you.
Yes.
Thanks, Ron.
I'll give you 5. We have a lot of questions.
All right.
Morning, sir.
Good morning. May it please the court. I'm Adam Griffin on behalf of the Appellant Tampa Electric Company.
Mr. Griffin, you would admit this is a hazardous place to work, isn't it?
Absolutely. And that is why Tampa Electric Company implements lockout tagout procedures.
Does that mean shut it down?
It does.
So it's a tag over it, or it's just a term?
It's just a term. It's, to be honest with you, I don't know all the details. I've always found it very confusing, but the lockout tagout means somebody has to go to another part of the plant. They turn off the equipment and then they put locks so that equipment can't be turned back on when the men are working on the equipment. So that's the lockout tagout. But and how that comes into play, I think it's necessary to talk about the facts and the facts that are in the record. Ganner and Carter and Zachary Industrial, this was an outage in that power plant. It was routine maintenance that was going to be done. Tampa Electric contracted with Zachary to clean this condenser and inlet tunnel. Part of the cleaning, when they leave, they were to close that access door, close and seal the access door. At 5:46 a.m. on the morning of the accident, and this is not disputed in the record, Mr. Ganner, the plaintiff in the case, put a note in the work order that said, close the tunnel for service, meaning they've done their job, it's ready to get back going.
So Mr. Ganner had opened and shut this door before.
Yes, Zachary Industrial,
Fastening it with the other bolts.
that's his company had. Who specifically had fastened it, it's not in the record, but Zachary Industrial closed that door. So that morning, again, there's a lot of routine maintenance going on in this power plant at this particular unit. And so Tampa Electric turns the condenser on. Now, the condenser it's binary. It's on and off. There's no pressure gauge. You don't turn up the pressure or turn down the pressure. So that morning, Tampa Electric turned it on. Bob Fitzpatrick, a senior manager in the plant, went by. He saw that there was a leak. He saw the leak. He was concerned because he knew it was salt water coming through that condenser inlet tunnel. And Tampa Electric takes that salt water from the floor of the plant and recycles it. So he put in a work order to, hey, we need to get this done. It's a top priority. So the maintenance supervisor, Mr. Kennedy, gets this. He sends 2 Tampa Electric men Mr. Michael and Mr. Butler down to perform this maintenance. They get down there and the unit's still running. So the water's running behind the door. There's pressure pushing out on the door is how it works. They tried to tighten it with the pump on. They were unsuccessful with that. That is why there was an OSHA violation, because they worked on that unit when it was hot and they should not have done it. The Tampa Electric employees, they were unsuccessful. They called for the unit to be turned off. It was turned off. Now the pressure's relieved. The pressure relieves. Now the bolts fall off. Now nothing broke. These are tabs and bolts, and they just came out because there wasn't pressure forcing the tabs against the bolts anymore. So when the door pressure relieved, the bolt was able to slip out. So there was nothing had broken.
So because it wasn't completely tightened when it was under pressure?
Correct. That's what we believe. And
there's just only so many reasons why that would happen.
Right. Yes, that's right. That's right.
Short of gremlins.
That's right. And so what do? We need to relieve the pressure. We need to tighten it. So they relieve the pressure. They tighten it down, kind of up against the gasket. But the way the door is, it's got to be even and it's got to be consistent. So they tighten it down and they go to lunch. At lunch, there's kind of a routine safety meeting they do every day, and Mr. Kennedy learns that Zachary had been the ones that morning, or I'm sorry, over the last few days, who had been cleaning the tunnel, and they were responsible to seal the door. So Tampa Electric tested again by turning the condenser on. The leak remained. The leak was smaller. It was the testimony is it was the size of a household faucet, about halfway open. So they didn't think anything of it. And Mr. Kennedy said, well, let's send Zachary to finish the job. Now, when Zachary, Mr. Ganner, and Mr. Carter go out there, they need to perform lockout, tagout before working on it while it's hot, or else they commit the same violation the Tampa Electric employees did. And so while they're standing there in front of the door with the unit running, which they need to do because they need to assess the problem, what it is. They don't need to be standing right in front, but they need to get their eyes on the problem. That's when they say the door was being blown open, when another Zachary person is going to lock out and tag out the unit so they can work on it safely. So there's this talk about pressure, about Tampa. There's no evidence Tampa Electric knew about any pressure. There's no evidence pressure even caused this.
Well, let's get to and thank you for that kind of bringing all that in a nice concise summation. But let's get to you've got a difficulty in that your trial judge remarked out loud that if I didn't consider this expert affidavit, I would deny the motion for summary judgment. But I'm not going to consider it. Crickets, silence. Why? I mean,
that's a good question.
Here's the thing: it's a pretty big deal. You would agree to do this for a while. You would agree that in the context of a summary judgment hearing, in a civil case, the refusal to consider an affidavit is a pretty big deal. There's got to be a legal reason for it. So,
well, he did not refuse. I thought the statement was a little odd, I'm not going to lie, but he did not refuse to consider the affidavit. He considered the affidavit, and he was very careful to make that clear. In the record on page 2008, he says, if Mr. Zagoulis' opinion, bottom line opinion expressed on page 20 of his report, lines 32 and 33, and I'll quote it. In my opinion, this is all his quote. In my opinion, comma, a variety of TICO's actions and failures worked together to create a situation that was virtually certain to result in injury and death to employees, close quote. And then the judge continues, if I was considering that and as part of this whole package, I would have come to a different conclusion. I would have denied the motion, but I just don't think that this opinion is permissible. His Honor remarks in the hearing several times that there was plenty of evidence of negligence in the affidavit, but that's not enough. The part that the trial judge excluded or disregarded was just that bottom line opinion. And he made that clear not only in page 2008, he made it clear in the order on appeal, as well as his questioning to counsel in the record on page 1989. He asked, how much should I be giving this bottom line opinion that all of those actions and failures create a situation that was virtually certain to result in injury or death in employees? Is that something I should consider? He didn't strike the affidavit entirely. I think he
Just the one part they really needed to use.
well, right, but it was also a legal conclusion, and Town of Palm Beach, and Gargunas,
Wasn't the legal conclusion, though, suppose the expert had said something along the lines of, I mean, the problem from their point of view is that what the expert did in that part, I'm gonna try Zeigler's, I want to go Zeigler's, said was, he parroted the statute and just said, basically, statutory language, virtue certainty, check the box, done. Which may have been indeed a legal conclusion that was improper for him to make. Or you can flip the coin and say, well, he's applying the facts in the framework that he was given to study them and applying them accordingly. Suppose he had said something along the line of, it was a 98% certainty, 90 to 98% certainty, or likelihood. Let's get certainty out of there altogether. So 90 to 98% likelihood that this portal would explode within 24 hours of his condition. Still a legal conclusion, or is now he just remarking about likelihoods?
well, I
expertise.
think it would still be a legal conclusion because I think he's doing the same thing.
Just probabilities are off the board. Experts can't apply on probabilities.
Well, he's doing the same thing just with different words in that situation, but the reality is here he is tracking the paper.
I'm just trying to find where that line is between what an expert can say about, because here's the thing,
yeah.
The statute requires some evidence of certainty. I mean, a fact finder is ultimately going to determine whether or not that there's a virtual certainty on this, or the court.
Sure.
So someone's going to have to determine this, either the court or the jury. I think it's more a court question if we go along the line of what you're suggesting, which is that this is a legal conclusion. They've got to be able to rely upon somebody.
Sure.
To be able to walk them through that. I didn't know how these things work until this case came across my desk.
That's absolutely right, and there's certainly a place for an expert witness. There's certainly a place for an expert witness here.
They just can't opine on what the statute.
They
What
can't.
the statute is.
Well, they can't render the legal conclusion. The Garganis opinion from the Florida Supreme Court is a good example.
So how would this, if you were plaintiff's counsel, how would you have fixed this affidavit?
I would have left out the last conclusion.
Okay, so you got a bunch of facts about it.
But here's the thing, there is nothing they could have done with this expert. There's nothing, because the facts are undisputed, and you can't just hire an expert at the last second and have him apply undisputed facts to a legal standard and survive.
Probably the best answer you can give from your perspective on that side of the podium. I'm not sure it's what I was hoping to hear.
But what I was saying was, with respect to the Garganis opinion, I mean, the question there was it depraved mind murder, was it first degree murder? And the experts could opine about what are the effects on mindset of intoxication and things like that. But when they go that next step and say, and therefore it's depraved mind, or therefore it's premeditated, that's where there's a problem. And so if an expert is used at all in this case, they can certainly educate a jury about the workings of a power plant. But what they can't do is go that extra step. Going back to the whole intentional tort standard, and I'll say this, even if this expert opinion came in entirely, even with that conclusion, he's saying it's virtually certain to happen. He's not saying Tampa Electric knew it was virtually certain to happen. So even if we allow this and ignore that first issue.
Yeah, it's the Monday morning quarterback.
Yeah.
Basically just projecting backwards in time and saying, well, now that we know all these facts, of course this is going to happen.
Right, and they still don't get there on the intentional tort because they have to have knowledge not only of a prior accident, but an explicit warning. And according to the R.L. Haynes opinion, it's not just that this door was going to blow, which they had no idea that would happen. It had never happened before, but that it would blow while these men were standing in front of it in the time, place, and manner that they would be injured. And so, that's just that the intentional tort standard, there's no evidence on any element that would support this claim. And the trial judge properly disregarded the expert's legal conclusion. If there's no other questions from the panel, I can conclude.
Thank you.
Thank you.
Yes, sir, you have 5 minutes.
Thank you, Your Honor. I'll try to talk as rapidly as I can. First of all, there's been some misrepresentation of fact to the court. There was no work order for the Ganser and Carter to go in that day. There was none. In fact, the work order they're talking about with cleaning the tunnels is an event that occurred almost a month earlier that was only closed out on 546 that morning. One had nothing to do with the other. And Ganser and Carter never went in to that unit until they went in and it blew, and they were only in there for a matter of seconds. Let's see. And again, there was no, as I said, no lockout. Going to our burden. I recognize in front of a jury that's a large burden. It's not just a simple negligence. Hey folks, they messed up. They should pay. This is a very hard burden. I also look at what separates our judicial system and the English judicial system from every other judicial system in the world is the right to a jury trial. It's in the Constitution. If I have my appellate shoes on, as I was asked, I would think, I said, okay, great. Is this so clear to me that I would absolutely dismiss the plaintiff's case? Or do I got to think about it? If I have to think about it, just like I know you all have done trials yourselves, when you dismiss a juror for cause, if the standard is beyond and to the exclusion of every reasonable doubt. So if you have a doubt about whether a juror should be excused for cause, they're gone. In this case, if you have a doubt about whether or not the summary judgment should have been granted, if my decision, and as an appellate judge, you say, I see arguments this way, I see arguments that way, and I would hesitate, I think under the granting of our great jury trial system, that the court should set aside this summary judgment. Allow us. I was told once by a very learned attorney, give me a jury and they'll give me justice. And I ask for us to have our chance in court to have a jury trial. There's no greater, there's nothing greater you can take away from anybody than the right to jury trial. In this case, there's insufficient evidence. And so I thank the court for its attention time, and I know you've spent a lot of time reading this. I know it's kind of new. I don't have time to distinguish all the other factual cases, but all the other cases are really substantially different. A couple of the cases there are clearly where the employee had notice, and there's no notice in this case, none at all, on behalf of Carnes and Garner. And then on the other cases where there's a pole falls in Haynes, that's three worked and one didn't. That's clearly negligence, but not enough to be that higher standard. In Publix, when the alarm didn't work on a truck and it backed up, well, this is the spotter back there. They know the truck's backing up, so there's knowledge. In the case where they crushed a hand, the guy knew that there was a greasy thing and used the hand. So all of those cases are pretty clearly distinguishable. This is a really kind of a unique fact pattern for you. Like I said, if the question is, do I or don't I, then there's only one true answer. And I thank the court for its time. And again, I thank my learned opponent.
Thank you very much. Well, there's a lot to think about. Have a nice rest of your day.